Welcome you all aspirants. In this today's video, we will be discussing about the current affairs which is from the polity section which is important for the UPSC Prelims 2026. And I'll be taking three important articles, three important current affairs news which can be a potential question. And we will try to discuss all of these three important current affairs within 15 to 20 minutes to make sure that the return on investment is absolutely maintained. So 15 minutes, you're just getting three important articles, the everything nook and corners, which is important for the prelims examination. Okay, so without any further ado, let's begin. So this is the very first video of the polity prelims current affairs, and let's start. First one is with respect to the vice president election. Recently in 2025, the vice president was elected. CP Radhakrishnan was recently elected as the 15th vice president of India, and the vice president is the second highest constitutional office in India. That is also very important. Next is it also serves as the ex officio chairman, because anyone who is elected as the vice president of India automatically becomes the chairman of Rajya Sabha. So hence this statement, the vice president is the ex officio chairman of Rajya Sabha, also is true. So now what are the key highlights with respect to the election process? See, first is with respect to the electoral college. Article 66 talks about this. So both the members of Lok Sabha and the Rajya Sabha, which includes elected and the nominated members, and the state legislative assemblies do not participate. Very important. And the value of each vote is 1. Okay, these are some of the important points with respect to the electoral college. Next is in terms of the method of election. It is through the proportional representation of single transferable votes, and also there is a secret ballot, and also there is a separate process where separate pens are even being given by the parliament, and the people should vote only using those pens. All of these things, very, very important. I mean, of course, it is good to know, but not essentially required to know. But whatever is mentioned in Lakshmikant absolutely becomes important. The nomination requirements, it needs 20 proposers, 20 seconders, and the person who is standing should also deposit 15,000 as a security. And then the conduct and the supervision with respect to the conduct, who is conducting the election. It is the Election Commission of India, and the returning officer is the Secretary General of Rajya Sabha, and the voting is held in the Parliament House. And a special ECI pen used. That's what I said. A special pen will be issued. It is called as the ECI pen. And also in voting, the first preference vote is definitely compulsory, and the violation of any secrecy, if is found, the vote becomes invalid. And anti-defection law here is not applicable. Very important. Anti-defection law in itself is a very important topic. Today we will be discussing one of the topic is anti-defection itself. So anti-defection law is not applicable here in this particular instance. Now talking about some of the important constitutional provisions with respect to the the vice president, is Article 63 means it says that there shall be a vice president. Next, Article 64 says that he is the ex officio chairman of the Rajya Sabha. And then Article 65, very, very important, because this is the article which talks about the vice president when he acts as a president during a short vacancy in the office of president. Next is Article 66, which talks about the election. 67, term resignation removal. Okay, fine. 68, election to fill vacancy. However, Article 65, very, very important to keep in mind. Next is qualifications. He should be a citizen of India. Minimum years is 35 years of age. Next, he should be a qualified member, or he should be a member qualified to become the Rajya Sabha member. Next, obviously, he should not hold any office of profit. And in terms of term and removal, 5 years is the term, and then continues until successor assumes office, and then the removal. A resolution passed by majority of total membership of the Rajya Sabha, and this is agreed to by Lok Sabha also later. And then no impeachment process so far has happened. That is also very important. Next is very important prelims facts which you have to keep in mind. First is the nominated members can vote. That is also very important. Now this is the overall summary of the entire topic, so which is very important from the prelims point of view. What is it? So the first one to keep in mind, that even the nominated members are also allowed to vote. Next is the value of vote is 1, unlike the presidential election. So now do let me know in the comment section as to what is the value of vote for the presidential election. Anyway, moving on forward, the Supreme Court decides the dispute with respect to elections conducted for the vice presidential, and then vice president has casting vote only as a chairman of Rajya Sabha. And then very important, 39th Constitutional Amendment Act 1975 attempted to remove Supreme Court jurisdiction over such disputes. Any disputes for that matter during, or let's say concerned with the election of the vice president, was removed, right? So this 39th Constitutional Amendment Act attempted to remove the Supreme Court jurisdiction. Okay, this is also important. You have to know. Next topic for today's video is 16th presidential reference, the Supreme Court judgment with respect to what the Supreme Court can do, especially when the bill is withheld for an indefinite period of time. However, we will discuss with respect to Article 143. The President referred questions to the Supreme Court, 16th presidential reference. What is the issue? Whether courts can impose timelines on the President or the Governor for not granting or not giving assent to bills under Article 200 and 201. So the Supreme Court gave some clarifications limiting the judicial intervention in the assent to bills, right? So it is simple, whether the courts have any say in areas or in matters when the President or the Governor withhold their assent to an indefinite period of time on certain bills, important bills. Simple. So what are the key highlights? First is no timelines can be imposed. Supreme Court clearly said that courts cannot fix any deadlines for President and the government to decide on the bills, because doing that, it will completely violate the federal feature of the country, the federal structure, especially the separation of powers, and also the constitutional case scheme, which has specifically given individual powers to both the President and the Governor, right? Next, it also said that deemed assent is unconstitutional. So courts cannot assume, it cannot sit under assumption that a bill is deemed assented if time lapses. Means if the time is taken indefinitely, doesn't mean, or courts cannot decide, or courts cannot come to a conclusion that the bill is given its assent, right? The bill is assumed to be passed or assented, right? It is not that. And however, this assent power is a constitutional function and not mechanical. Not mechanical here means just because time lapses, it doesn't mean that the assent is given. It is a constitutional function, and there is a separate or let's say clear instructions which is given in the Constitution itself. Next is cannot sit indefinitely on bills. However, Supreme Court stayed out from putting its, giving its conclusions on certain bills which are left for an indefinite period of time. Still, it said the Governor or the President cannot keep the bills pending forever, right? Because if you know how the process of the entire things happen, because see, even when the state legislature, when it passes a bill, it goes to, let's say, the governor of that particular state. Now, governor has three options. One is to give the assent to the bill. Next is to withhold, right? To withhold means the bill is rejected then and there. Next is to return to the state legislature. And the fourth option is reserve it for the president's consent, right? So now, if he is giving his assent, it obviously becomes a bill. If he is withholding, it gets rejected. The bill absolutely gets rejected. And if the governor is returning the bill back to the state legislature, keep in mind, very important, if the governor is returning the bill back to the state legislature and the state legislature once again passes it, maybe with change or without change, now the governor must give his assent. This is what the condition is, right? And on the other hand, now let's say if the governor is reserving a particular bill for the president, for the president's consideration, now the president once again has three options. He either can give his assent or withhold, right? And he can, even return as well. Now there is a condition. Now once he returns it back to the state legislature, let's say the state legislature once again sends it back to the president, even with or without any changes, right? Maybe with some alterations or without any alterations. Now the president is not bound to give the assent. Very important. In the latter case, what happened? The government must give his assent if the state legislature is sending it back to him. But here, even if the president is returning the bill and if it is coming back to the president may not, or president is not bound to give his assent. Very important. And this returning and all of those things, there's an exception. Exception is money bill, which I hope you know. Anyway, so this is the entire tedious process, right? So hence, a huge framing or proper provisions were supposed to be made on these particular things. So hence all of these things, and also it was very much in use, especially Tamil Nadu versus the governor of the state. Very, very important, right? And next important feature is the limited judicial review. And yeah, the delay, what we are talking about, the delay which happens by the governor or even the president, it violates the federalism. It undermines the legislature's will, the state legislature's will, and it violates the constitutional morality as well. So these are the three important features that it absolutely violates. Next is the limited judicial review. Courts can intervene only if there is a malified intent, means this is one of the important verdict. And next is with respect to the procedural violation, and also the courts cannot review merits of the bill. Courts cannot do or cannot talk about the bill if it is good or bad and all of those things, but rather if there is a malified intent in the bill, in the procedure, in the passing, or let's say if there's any violation in the procedure, if let's say any violation happens in this procedure, that's when courts can get into what it has to do, right? So the judicial review, the limitations of judicial review is what was also discussed. Next is no mandatory Supreme Court advice. So president is not bound to seek Supreme Court advice whenever a bill is reserved. That is also one of the important directions given by the Supreme Court. And president's subjective satisfaction is sufficient. This is also important. Means the president need not always keep the bill on hold, saying that it has been reserved for the Supreme Court's advice. Rather, he can just take a subjective decision on himself, which satisfies himself, which is more than enough or more than sufficient, is what the Supreme Court said. However, with respect to this, there are important constitutional provisions. 143, very important, where it says that president may seek advisory opinion of the Supreme Court. Next, Article 200 talks about the governor's assent, and we have Article 201, which talks about the president's assent. Next, we have the Article 163, subclause 2, where we talk about governor can act in discretionary capacity in certain matters. The president does not have suo motu power to take up state bills, but bill must first be reserved by the governor. So, not much important, but good to know. Next is why this even popped up, because of the Tamil Nadu versus the governor case, right? So I think all those cases are not much of importance, and that's all. Next is the anti-defection law, the recent Supreme Court judgment 2025. So here in the famous Padi Kaushik Reddy versus the state of Telangana 2025, the Supreme Court addressed delay by the Speaker of Telangana Assembly in deciding the disqualification petitions against 10 MLAs, right? And the issue, what is the issue? Delay in deciding the petitions under the anti-defection law. Very important. So anti-defection law, every year there's a question. Not every year, but at least this is UPSC's hot favorite. UPSC has asked questions earlier, so it is important to know. So what is anti-defection law? Some of the important key facts. One is the constitutional basis with respect to the constitution. It was inserted through the 52nd Constitutional Amendment Act 1985, and this was added in the 10th schedule. 10th schedule is also famously known as the anti-defection law itself, and this was introduced to curb the political defections, Ayaram, Gayaram, the famous wordings that we have, right? So what are the grounds of disqualification now? This is against an MLA or an MP, who can be disqualified if voluntarily he is giving up his membership of a political party after he is being elected. Now voluntarily is giving up his membership, then it is considered as a disqualification under anti-defection law. Next, votes or abstains contrary to party whip without permission. There is a political party, and every political party will have a political whip, right? He's the one who tries to bring consensus in the party. And now if a particular member of the parliament or member or particular party member abstains to vote or votes in against or in contrary to the party's consensus, right, without permission, that is also important. So that is also considered as anti-defection. Next is independent members who is joining a political party. That is also important. Those are all very clearly given in the Lakshmikant Parliament chapter. So any independent member, whosoever is elected not from any political party, if he joins a political party, then it is also considered a defection. Nominated member joins a political party after 6 months, that is also considered as an the defection under 10th schedule, right? However, Individual the member who joins a political party defection, individual defection is not permitted, but group defection is possible, right? That is also important, one of the important point for the prelims. Keep in mind. Next, who makes the decision, who decides the defection? So it is usually taken by the speaker, right? And in terms of the parliament of the Rajya Sabha, it is the chairman basically for the Rajya Sabha, and speaker both in terms of the state legislature and the Lok Sabha. And it is based on the petition filed by any member of the house. So basically, directly speaker cannot take this into his hands. Someone in the house should file a petition, and based on that, it can happen. That is what it is. Next is, what are the important limitations? No time limit specified in 10th schedule for deciding disqualification petition. So in fact, if you see why we are even studying this, or the context is because of that, because there is a loophole inside the constitution itself. This is the biggest limitation, which means there is no time limitation given on the speaker to decide the defection, the cases on defection, and that itself is the biggest problem here, right? And talking with respect to the judicial review, courts can intervene only after speaker gives the decision. Gives means speaker should give the decision only after that, and speaker's decision is subject to judicial review. That's what, based on whatever the speaker has to say about the disqualification of its members, only then the Supreme Court or the court can get in, right? Only then the judicial review is possible. And this judicial review is also one and the same thing. We're saying vice versa. Courts can intervene only after the speaker gives his decision. Next is some of the important judicial pronouncements. First is Quixoto Holohan versus Jachilu 1992, which upheld the constitutional validity of the 10th schedule, right? Next, Ravi S. Naik versus Union of India 1994, which talks about the conduct of member can imply defection. Voluntarily giving up membership does not require formal resignation, right? So these are some of the important provisions. Not all is important, just the important cases with respect to anti-defection law, if you know, that's sufficient. First is Quixoto Holohan. Next is Ravi S. Naik versus Union of India. Next is Karnataka MLA's defection disqualification case 2020. Kisham Mega Chandra Singh 2020. More than sufficient. Next is the facts, important facts with respect to your anti-defection for prelims. You have to keep in mind, original constitution 1950 did not mention political party, right? Term introduced via 10th schedule only. It was introduced in the 10th schedule, it was introduced only in the year 1985 when the 10th schedule was added. Next, anti-defection law does not apply to presidential and vice presidential elections. We studied before. Next is merger valid only if 2/3 members agree. This is what I said. Group mergers or group defection is allowed, but not individual defection, right? Only if 2/3 members of a particular political party agrees, then the merger is allowed between two political parties. Power lies with presiding officer, be it speaker or chairman, and not the election commission. Keep in mind, UPSC will twist it here. It's not the election commission, it's the speaker or the chairman of the Rajya Sabha. Key constitutional amendments related to your anti-defection. First one is 52nd Act, which inserted the 10th schedule. Next is the 91st Amendment Act 2003, which strengthened the anti-defection law, removed provision for a split, which was 1/3. Next, limited size of Council of Ministers to 15%. Anyway, that's all for this particular video. We have gone, pretty much in every nook and corners of all these three concepts. More than sufficient, for you to understand or even to solve any question from these three topics. Stay tuned. We will come with more such interesting videos, and we will discuss 3 to 4 important articles like this as much as possible, and we will, ensure that these things will definitely help you give your best and productive prelims this year. Signing off. This is Madan Gopal. Have a beautiful day.